Now, as I mentioned, that medical negligence is an important part of our Consumer Protection Act. We'll see what is medical negligence in depth, how you can write your answer. I think this is one of the most loved questions of your paper setters. So what does medical negligence mean? It just means that there is failure or that there is deficiency in some treatment to the patient, and it is supposed to be in line with the medical standards of care. Now, there are set procedures, there are set standards when it comes to medicine, because the doctor cannot just do what he wants to do. It is all pre-decided. Say, for example, you have so and so amount of such a disease, then say 40%, then you are supposed to be given X medicine. If it goes beyond that line, you are supposed to give some other medicine. So it's all set. And that's why whatever the professional, the doctor is administering to the patient should be in line with the accepted medical standards of care. Now, next one is, if the medical personnel has given incorrect treatment or carelessly the person has performed a surgery, or maybe negligence. It already says medical negligence. So the person is negligent. The person doesn't know. You might have seen this movie Ankur Arora, murder case. In that, it is beautifully shown that just because of the negligence of the doctor, the boy dies. That actual case is also mentioned in our forthcoming PPT. So that is negligent, where the person is careless. The person has not taken due care to see to it that the patient is given right and proper treatment. That's what medical negligence means. Also, it includes inadequate and inappropriate care that leads to avoidable harm. Now, something that can be avoided, you should see to it that you take due care. But if you are not that careful, then certainly things are going to go beyond maybe any harm that you can cause to the person. Now, the point is that, see, when a person goes to the doctor, the person is already ailing. The person is already in some kind of a situation that he is not able to do some things, or rather his body is facing some issues. Now, in that period of time, or in that case, he needs to be treated properly. And if the doctor avoids or does not do certain things, then it will become harmful for the patient. Now, next is a broad area of civil law that allows injured patients to seek damages. As we spoke about some compensation earlier, if there is any negligent treatment given, then he can seek damages from the hospital. So what are the elements to prove medical negligence? Any person cannot just go and say that the doctor has been negligent. So what are the elements to be proven as far as medical negligence is concerned? So one is that the doctor had a duty of care towards the patient. Say a hospital has 10 doctors and there is one doctor assigned for you. Now, the person is, say, admitted in the hospital as a cancer patient, and there is another patient, another doctor who's treating, say, a corona patient maybe. So will that doctor be responsible for the cancer patient's health? No. So first of all, it is important to prove that the concerned person, or maybe even the hospital, there are cases against even the hospital, not that just the doctors. The point to be proven here is that there is a duty of care. If there is no duty, then there cannot be a breach of that duty. So for deficiency, first of all, the duty should exist. Then the person has to prove that there has to be a breach of duty, thereby leading to worsening of condition of the patient, that is harm. And last is the damages that the person may seek from the hospital or the doctor or the clinic. So these are the elements which are supposed to be proven. Now, what are the popular defenses that the advocate can take if the doctor is sued? Obviously, you are a defense counsel, you are a criminal defense lawyer. So defense is an important part. Your accused is a doctor. You are in a put up in a case where the person who's accused of certain harm to the patient is a doctor, what are the defenses that you can seek? When you construct your answer in such a manner, it's a long answer. Introduction, what is medical negligence? Point number 2, what are the points to be proven, key points to prove that there was a medical negligence that took place, the one which we saw in second slide. And now the popular defenses that the advocate can take. At the end of the day, you are a law student. So this is the most important part. If you can write this about defenses properly and elaborate the answer, that will be great. Please note that if you underline at least these 4 points, then you will really score well. Because we as law students, when we graduate, we will be going and practicing. So for us, defenses are most important. One is that patient has signed informed consent and he has taken the risk of the, say, surgery or the treatment voluntarily. So first of all, it is important to tell the patient, to make him aware what kind of treatment he is going to undergo and that such and such risk may ensue. So informing him is very important. As per my understanding, informed consent is one of your short answers, one of your small questions, and we will see that later. Second is patient failed to disclose vital health information. Now, the doctor is not someone who is your childhood friend and he doesn't know what is happening in your life. So if there is some certain health problem or something that had happened in the past, say 5 years back, that might have left traces in your body, or the medication might have left some traces, or some other condition which we as normal persons don't understand, the doctor will. So not disclosing such vital information may lead to certain risks, and that the person, you must have heard, no? People say you should never lie to a doctor and an advocate, because both the people are going to save your life. So with the doctor, you have to share all your medical history, whatever that had happened. And if that is not disclosed and he is seeking risk on his own, then the doctor is not responsible for whatever happens to the patient. Anything happening at the end of the day and you start blaming the doctor, that's not done. So this is certain protection given to the doctors and to the hospitals, whereas medical negligence cases are concerned. Next one is by their own negligence, the patient has caused harm. Now in Ankur Arora murder case, you might have seen that the boy eats, he is prohibited from eating some hours, few hours before the surgery. But he's a small boy, he eats something. Of course, it is a negligence on the part of the doctor because the boy is small, the mother didn't know. But see, if the person has done it consciously, then it's not the negligence on part of the doctor. So this is all a matter of trial, of course, but patient has caused harm by his own negligence is one of the popular defenses that the accused can say. And fourth one is their actions resulted in greater injuries. So maybe the doctor has told you to take care, eat this, don't do that, don't move around. Say, for example, a person has undergone knee surgery. Maybe there are certain techniques or something to be cared for. Don't walk, don't stand for long, or etc. etc. I'm just giving a common example. Something has told by the doctor to be taken care of, and the person is not agreeing with it, he's just doing at his whims and fancies, then these own actions are going to cause greater injuries. Is the doctor responsible at the end of the day for such careless behavior on the part of the patient? No. So this is one of the important defenses that you can cite. Next. So now coming from all these parts of the answer, we see that there are 6 landmark judgments of the Supreme Court which is pertaining to medical negligence. Now, Kunal Saha versus AMRI, I think you should go through these and cite 1 or 2 in your answer wherever you can, because these are important landmark judgments which have defined and which have brought up the point that medical negligence is an important part when it comes to cases, medical legal cases, it is very important. So Aparna Datta versus Apollo Hospital, that case that I was talking about, Ankur Arora murder case, that is Spring Meadows Hospital versus Harjol Ahluwalia. So, of course, the patient, through his parents, had sued the hospital, and it was proved that there was medical negligence on the part of the operating surgeon, and they did get some compensation. So you can go through these 5-6 judgments and cite at least one or two in your answers. When you are writing about medical negligence or any other part which is related to medical negligence, you can cite these. Even if you write one judgment 2 times in 2 different answers, that is also okay. It just means that you've understood. For example, what I mean here is, when you talk about confidentiality between doctor and patient, and there you mention that in an exception, the doctor can say tell the facts or the details about the case in such and such case. Then you can write the case over there. Anything that relates to medical negligence, you can cite one or two judgments from here. So this is like a bucket list of your landmark judgments which relates to medical negligence.